Gideon versus Wainwright, a case in which the Sixth Amendment was brought upon the Supreme Court. Clarence Gideon was a man with very little education. He ran away from home while in the 8th grade and spent much of his early adult life in and out of trouble. He spent multiple occasions in prison for non-violent crimes. This case starts when Gideon was charged with breaking and entering with the intent to commit a misdemeanor.
In the state of Florida, this offense is considered a felony. When he showed up to the trial, he did not have an attorney with him. In the court session, he asked the judge to appoint counsel to him since he claimed that he could not afford an attorney. The judge denied his request to provide counsel because in Florida, the law states that they only have to provide counsel for the poor who are charged with capital offenses.
Since Gideon was not appointed any counsel, he ended up representing himself during the trial. He made his best efforts and did everything he knew how to do. He made an opening statement to the jury, cross-examined the prosecution's witness, presented witness in his own defense, declined to testify himself, and made arguments emphasizing his innocence. Despite all of his efforts, the jury found him guilty and sentenced him to 5 years in prison.
Gideon found some sort of relief in this conviction by filing a petition to the Florida Supreme Court. He filed a petition for writ of habeas corpus. In the petition, he challenged his conviction and sentence on the fact that the trial's judge's refusal to appoint counsel clearly violated his constitutional rights. However, the Florida Supreme Court denied his petition.
Gideon decided that he was not going to stop there, so he filed in a handwritten petition to the Supreme Court of the United States. The court ended up taking his case in order to resolve the question of whether the right to counsel guaranteed under the Sixth Amendment of the Constitution applies to the defendants in the state court.
This case had brought questions upon the case of Betts v. Brady and whether or not it needed to be reconsidered. Betts v. Brady had brought up the original question that the refusal to appoint counsel for an indigent defendant charged with a felony in the state court did not necessarily violate the due process clause of the 14th Amendment. When the Supreme Court decided to take on Gideon's case, they had to further decide if Betts' case should be reconsidered.
Since Florida's Supreme Court upheld the ruling of the lower court, Gideon decided to file a petition with the U.S. Supreme Court. This was not the first time the court has dealt with cases involving the right to counsel. In 1932, Powell v. Alabama, the court had ruled that state courts must provide legal counsel to indigent defendants charged with capital crimes. This changed with Betts v. Brady in 1942, when the court decided that legal counsel wasn't required for indigent defendants.
On July 15, 1963, the court heard arguments of the Gideon v. Wainwright case. Abe Fortas represented Gideon, arguing that Gideon was a special case since he had only had an 8th grade education. Fortas also argued that no matter how competent or educated someone is, the U.S. Constitution guarantees a person charged with a felony is ensured legal representation. On March 18, 1963, the Supreme Court ruled 9-0 that states are required to provide legal consultation to indigent defendants charged with a felony.
Shortly after the court heard arguments from the Gideon v. Wainwright case, they accepted that the Sixth Amendment must be guaranteed in state courts. The right to legal counsel is required for state courts by the 14th Amendment due process law. The states are not allowed to deprive any person of life, liberty, and property without due process of law. This decision overturned the Betts v. Brady case. Gideon was later granted retrial, in which he was acquitted in 1963. Gideon fought and made it possible for all people to this day to have representation, no matter how poor one may be.